Good evening, everyone. It's 6:30 and time to start. This is the August 19, 2026 meeting. There we go. Make sure your mics are on. This is the August 19, 2026 meeting of the Town of Harpswell Planning Board. Would you please rise with me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, for tonight's meeting, we have 4 items of business, one of which is a public hearing on some proposed ordinance amendments. And the other 3 are 3 matters of old business, which have been carried over from prior meetings. There was a 4th matter of old business, but that was withdrawn, so we will not be considering that tonight. The order of the meeting, it shows here that we're going to have a public hearing first, but because we have so many people here for purposes of the items of old business, we will have the public hearing following the matters of old business. We have a quorum here tonight. We have 3 regular members of the board and 2 alternates who will be voting members. So let's see if we have 2 members there remote. Would you identify yourselves, please? Start, Courtney.
Yes, Courtney Snellings.
Heather
Allen.
Okay.
Jim Bobarski.
Dan Hobeck.
Lori Falcone.
Margaret McIntyre, the town planner.
Okay, so we do have a quorum. Let's proceed to our first item of old business, which is Angela Blair, owner Peter Spencer Waterman Marine Corp., applicant map 5 lot 59, 42 Hildreth Road. This is the consideration of an application for a new residential wharf in the Resource Protection District. Basically, the applicant is asking for to install a dock consisting of a pier and a seasonal ramp and float to provide access to the water. Let's see. All of a sudden, oh, here we go. The float will be stored off-site in an upland location in the off-season. In addition to other approvals, the proposed dock requires review and approval by the planning board under the shoreline zoning ordinance. This matter came before the board once before, and it was continued to this meeting. I believe there was a second site visit that was done.
Mm-hmm. Yes.
Is there someone who would care to report on that? Go ahead, Courtney.
I went on the site visit. Yes, this was a site visit from the beach area. I was not present for the other site visit, the upper visit, but an area of concern was that a property close to this particular property seems to have an erosion issue. And it's not vegetated, and because it's not vegetated, it's eroded. And we had a concern that the piece of property that wishes to put in the dock, if the vegetation is removed in order to be able to put the dock there, that erosion might occur. And of course, that was a concern since it's the cliff line eroding away potentially.
All right. You're coming through fairly quietly today, Courtney. So, so Margaret
Is that better? Wait a minute.
No, it isn't on your end. It's on our end, I believe.
Oh, do I need to say that again?
It's a little better.
A little better.
Because I'm yelling. Okay, but I can,
Well, you're from a
was in
long
the
ways
classroom.
away,
I
no
can
wonder
yell.
we can,
okay, all right, so,
All
It
right.
should be fun.
that's better.
Yeah, if you just
Okay.
speak up, you too, Heather, it was a little hard to hear you as well.
sorry. Anyway, we went down the public landing in order to get onto the beach so we could look at the cliff where the dock would be, and the pier would be put in, and it's heavily vegetated. We couldn't tell what was happening there, but in a property that was either next to it or several, there's no lot lines, obviously, down there on the beach, but there was a badly eroded section of the cliff. I'm assuming that the cliff is made of the same materials throughout and had concern with fooling around up there that we would get erosion on the cliff because we're losing land, as we know. So I just want to bring that particular concern up. Could you guys hear me now?
Yes.
Yeah.
Yep.
Yes.
Hopefully. Okay.
Okay. Thank you. Margaret, do you have any comments? I know there's been a revised pier location. Do you want to speak to that or to have them?
The applicant sent me a revised pier location a couple days ago, maybe last week. And it is in the northern, it's on the northern end of the property in the most gentle slope that's not currently vegetated. When we were there over the summer, it's just covered in leaves. So it's definitely not the steep, erodible, really well vegetated slope that we saw the first time we were there.
Okay,
And I'm
what,
prepared to revise our draft motions when we get there to reflect that change.
okay. All right, could we hear from the applicant a little bit, just to give us again a summary of what you had proposed?
Mr. Chairman, Peter Spencer from Waterman Marine. I'm sorry, I didn't hear many of the comments, but to deal with the matter of the site location, the codes enforcement officer had a site review at the end of July, and we reviewed the site. And the area of erosion that I think Margaret is speaking of is where we had originally chosen to put the pier. When we moved it over 30 feet to the north, there's a much better location. The angle of pitch is reduced, and there is no erosion present at that site. So, and I think this is a much better solution. The codes enforcement people agreed that this was a much better place to be than we had originally chosen. And the reason for that, we often try to choose towards the center of the property because the traffic from the house comes out from the back porch right into that area, but it didn't make any sense to put the system in that particular location.
All right, thank you. Are there any additional comments from the board before we go through the standards of approval here? Yeah, Courtney?
Would this be the place to ask codes to comment or after we have read the standards of approval?
We can ask them to, having codes comment now might make it easier for the board to talk further. So would somebody from codes care to comment?
I'd agree with,
Would
that
you-
we agree.
Would you
Oh,
identify?
I'm sorry, Tim with codes. I would agree that what he showed us, that it was the better spot as far as erosion was concerned to put it in the spot that we talked about.
All right, thank you.
I guess I might add there was some elevation issues with at the meeting in July, and this site location removes a good part of that, and there is no erosion whatsoever at this site. So it's a clear path down, very little vegetation, and a good spot for what we'd like to do.
All right, thank you very much. All right, Margaret, you said that you had some revisions to the proposed? All right, what we have in front of us and what has been posted on the website, and anything that we have incidentally on, as members of the planning board, is also available to the public on our website. So you see everything that we see. So the issue is one of conformance with the submission requirements. Section 15.3 of the Shoreline Zoning Ordinance sets out the standards for piers, docks, wharfs, and similar structures. The applicant has addressed conformance of the proposals with the standards of the application. The town planner has made recommendations on each of the subsections of the section 15.3, and those are incorporated by reference in anything that we do in terms of our decision. So I think we should probably just go through them, and then you can tell me where
Sure.
the issue, okay. And then the board can speak to any of those. And once we are completed going through those ourselves, then members of the public are invited to speak to this as well, all right? So 15.3.1 says no more than one pier, dock, or wharf or similar structure is allowed on a single lot. The limit shall not apply to functionally related water uses, marine-related businesses, commercial fishing activities, and marinas. And the recommendation of the planner is that the standard is met on the finding that the applicant proposes to install one dock to serve the lot. Are there any comments from the board? No. 15.3.2, access from the shore shall be developed on soils appropriate for such use and constructed so as to control erosion. And I think at this point,
I would say the standard is met based on the finding that the structure will be built on the most appropriate location on the lot. Appropriate, practical, whatever. I don't know. I was trying to figure out a good word to
Practical.
say.
practical.
All right.
Yeah.
Practical. All right. So the standards is met based on the finding that the structure will be built on the most practical location on the lot.
Okay. Any comments from the board? All right, 15.3.3, the location will not interfere with any existing developed or natural beach areas. That standard is met based on the finding that the location is not in the vicinity of existing or natural beach areas. Any comments from the board?
No.
15.3.4, the facility shall be located so as to minimize adverse effects on fisheries. Standard is met based on the finding that the
Okay. The standard is met based on the following this standard is met based on the following findings. The harbor master has determined that the dock will not interfere with commercial fishing uses. And number 2, hold on just a second. The harbor master will review this application and her findings will be presented to the select board prior to town approval.
okay.
She, as much as I tried to track her down to get the sign off before this meeting, it didn't happen, but she swears that she is ready to sign off on it.
Okay,
She swore that she already had signed off on it, but she hasn't, so.
Okay.
We'll get.
so it's just a formality of taking what she told you verbally and putting it in writing? Okay.
And it needs, the code office will need it to bring it to the select board, so it can't proceed without it.
Okay, section 15.3.5, the facility shall be no larger in dimension than necessary to carry on the activity and be consistent with the surrounding character and uses of the area. And that includes 3 subparagraphs. The planner suggests that this standard is met based on the findings that the dock is for non-commercial use, the pier will be 6 feet in width, and will not extend beyond mean low water. Any questions, comments from the board?
I have one. The pier is going to be 5 feet in width,
5 feet in
That's
width
an
rather
error on
than
my
6 feet in width,
right?
okay?
Is that correct? It's going to be 5 feet wide instead of 6 feet wide. All right.
And that's why we go through these item by item. Section 15.3.6, no new structure shall be built on or abutting a pier, wharf, or dock or other structure. Commercial fishing structures requiring direct access to the water as an operational necessity are allowed. This standard is met based on the finding that the applicants do not propose constructing any structures on, over, or abutting the dock. Questions or comments from the board? 15.3.7, no existing structure built on, over, or abutting a pier extending beyond the maximum high water line shall be converted to residential units in any district. This standard is met based on the findings that the application is for the construction of a new seasonal dock. As such, there are no existing structures on the proposed dock. Questions, comments from the board?
No.
15.3.8, except in the commercial fisheries 1 district, structures built or abutting a pier or other structure extending beyond the maximum high water line of a stream tributary stream upland edge of a coastal wetland or within a freshwater wetland shall not exceed 20 feet in height above the pier. This standard is met based on the finding that the applicant does not propose constructing any structures on, over, or abutting the dock. Questions, comments from the board? 15.3.9, no new wharf, pier, or dock shall be constructed on a lot shown on a recorded subdivision plan that has deeded rights of access to the wharf, pier, dock, etc. This standard is met based on the finding that the lot is not part of a subdivision. Questions, comments from the board? 15.3.10, new permanent docks or piers on non-tidal waters shall not be allowed unless it is demonstrated that a temporary pier or dock is not feasible. This standard is met based on the finding that the application is for a seasonal dock located in the tidal waters. Questions, comments from the board? Okay, 15.3.11, vegetation may be removed in excess of the standards of 15.15 of this ordinance in order to conduct shoreland stabilization. This standard is met based on the finding that the project does not include shoreland stabilization. Any other questions, comments from the board concerning this or any of the other standards that we've discussed? Is there anyone from the public who wishes to speak to any of these items that we've discussed? All right, hearing none, I move that the planning board finds that the application of Angela Blair does meet the standards of section 15.3 of the Shoreland Zoning Ordinance based on the findings as presented by the town planner and as amended by her comments at this meeting that are incorporated into this motion by reference. Is there support for the motion? It is seconded. Since some of the members are attending by way of Zoom, we have to vote verbally rather than just by raise of hands. Courtney?
Courtney Snelling's aye.
Heather?
Heather Allen, aye.
Jim?
Jim Bobarski, aye.
Dan Hoback, aye.
Lori Falcone, aye.
The motion is carried 5-0. So conclusions of law, in light of the findings of fact and with consideration of the supporting documentation in the record, I move that the planning board reaches the following conclusions. The planning board finds that the applicant, Angela Blair, has met the standards of the Town of Harpswell zoning ordinance. The planning board approves the application and site plan for the wharf in Resource Protection District at 42 Hildreth Road, which is map 5 lot 59, with the following standard conditions of approval. One, this approval is not final until such time as the notice of decision has been signed by the chair of the planning board. Two, the approval is based on the application, including the drawings of the proposed dock prepared by
Waterman Marine.
Waterman Marine, and all submissions and information provided by the applicant at final approval, whether referenced any findings or conditions of approval. Three, the approval is dependent upon and limited to the proposal and plans contained in the application and supporting documents submitted to and affirmed by the applicant. Any variation from the plan proposals and supporting documents, except de minimis changes as determined by the town planner that do not affect approval standards, is subject to the review and approval of the planning board prior to implementation. Four, the applicant shall comply with all state and federal rules and regulations that apply to the application. That is the motion. Do I have a second?
Yes.
Motion is seconded. Call for a vote from the board. Courtney?
Courtney Snelling's aye.
Heather?
Heather Allen, aye.
Jim Babarski, aye.
Dan Hoback, aye.
Lori Falcone, aye.
The motion passes unanimously. Congratulations. And, you'll talk to the planner afterwards, and as soon as the paperwork is prepared, I will sign it as chair of the board. All right.
Thank you. Thanks for coming back.
Yeah, this is a good example of when we take a look at an application, taking a second look at it to see if there is a better location for the dock. And in this case, everything worked out to everyone's satisfaction, so thank you. Okay, second item of old business is item 26-0701, the David W. Abel Trust of 2020, Flycatcher LLC, applicant map 7, lot 171, 209 High Head Road, consideration of an application for a new residential wharf in the Resource Protection District. This, again, is a matter that was carried over from the prior meeting. Margaret, would you give us an update on anything?
At the last meeting, the planning board voted on all of the items in section 15.3 of the shoreline zoning ordinance, except 15.3.9. The application was tabled so that our attorney would be able to attend the meeting to give us some representation, but she was unable to attend the meeting. So things haven't really changed much since the last time we spoke.
Okay. And what we were looking for from the town attorney was whether there was any update to the legal opinion that she provided for a prior application on High Head Road. Is that correct?
Yes.
Okay. So with no update from the attorney, I'm going to ask the board first I'm going to ask the applicant or the representative if they have anything that they would care to add at this point before we consider.
Hi, Kristen Collins, Pretty Flaherty. Speaking on behalf of both of the applications that are on the table tonight. I think there are two differences between the legal opinion that you have and where we are today. One, I do think there is a distinguishing factor here that I do think the planning board relied on to some extent with that Lawrence, or I can't remember his name, I'm sorry, the application from 2024, Hegarty. And that was that application had on that property been subject to a subdivision review to move a lot line since the enactment of this provision that we're talking about. And the other thing is, we weren't there. We weren't explaining our point of view as to why this ordinance doesn't and shouldn't apply in this situation. While some of the arguments were raised, I think we fleshed them out a lot more thoroughly. And I think there, again, just to reiterate, number one, these properties do not have deeded access to a dock. They have deeded access to a piece of property that is the High Head Yacht Club, but there was no promise, no indication, no guarantee that there would be a dock and will be a dock on this property in perpetuity. And then the other thing, of course, is that this is a subdivision that preceded not only the enactment of this ordinance by decades, but preceded the enactment of the main subdivision law. And as I pointed out the last time we were here, this subdivision wasn't even approved by a planning board. It was signed off on by the select board. We have no idea the extent of the review that was given. And, to apply the ordinance in this context, I really think is an unconstitutional taking. As we've said and shown you, I can't remember if I gave you the exhibit, but I do have an exhibit that I gave the select board that has something to the effect of 30 or 40 docks in old subdivisions that have community docks that this town has permitted, many of them since the enactment of these provisions in 2007, to stop doing that, to take these rights away from people who purchased in an old development with no reason to believe that it was going to be subject to this provision, or people who purchased way before this ordinance, expecting they would be able to build a dock just like their neighbors had, and now take that right away from them because of this interpretation of the ordinance. I think that's really problematic. There is a path to read this ordinance and apply this ordinance that is fair and that gives these people their docks just like their neighbors have in the same developments, and I'm urging you to take that path. Thank you.
Thank you, Counselor. There any comments from the board? Okay, hearing none from anyone else. There are a couple of things that are going on here. One of which is that we do have an existing legal opinion on the concept of that was already dealt with in High Head. And when we receive a legal opinion, we're pretty well bound by it. One of the issues that we have as a planning board is that there are areas in which we have a lot of discretion, and there are areas in which we have no discretion. One of the areas where we have a lot of discretion is, let's say you have a non-conforming use in a building that's being torn down and somebody wants to put a replacement in there. We have discretion to say, are they making it more conform, making the property more, or the building more conformable to the greatest possible extent. That's one of those areas where we can exercise our own discretion. One of the issues here, according to the opinion that we received from our attorney, is we really don't have that discretion here. That I'm just speaking for myself based on what the attorney has said. What other planning board members may decide to do to vote on that is of course their own judgment. One of the things that we've been talking about, based on not only this but some other similar situation, is the reason for the public hearing that's going to be coming up later on. And what that would do is that will create an ordinance amendment which would create some exceptions to the rule that we've been following, and also give the planning board a little bit more discretion to try to avoid what council has suggested might be an unconstitutional taking. So that is one of the reasons why, with the experiences that we have had, and in order to create as much fairness as possible, why we're considering an ordinance amendment, which will then go to the select board and upon their approval be voted on by the members of the town of the residents of the town of Harpswell. So I hope that gives you a little bit broader perspective on what we're dealing with and what kind of discretion we have when we've received a legal opinion. So, do you have any other comments?
Not at this time, sorry.
Okay. Are there any other questions or comments from the other members of the board? Okay. Hearing none, are there any other comments or questions from the members of the public? Yeah, please identify yourself and.
My name is Joe Johnson. I live at 375 High Head. We are not able to have a deep water dock because of where we are located. There are at least 47 other homes on High Head that are not able to have deep water docks. That being said, those people really need to be able to, if they have a boat, be able to use the public area of our clubhouse. Prohibiting people, and I'm not sure when this prior legal decision was made, and if it was based on lots, believe it was 71, no, it wasn't 71, 31 maybe, and 30. That was actually a lot that was broken up, so that may have been why they decided it was a subdivision. But the rest of us, it's a homeowners association. So for people, there's only 13 deep water docks that really exist right now on High Head. And to allow a couple more that are more than half a mile away, I believe, puts a real burden on those people. And I think when people buy a lot, a home on High Head, they have expectations, and there should be no reason why I think that they can't have a deep water dock. That's my opinion. Okay?
Thank you very much.
Thank you.
No, and it's interesting that you mentioned a half mile, because that is one of the provisions that is in the proposed ordinance, is to talk about that people who are more than a half a mile.
It's a long way to row, or
Yeah, that's a long way to row, certainly. Yeah.
a real burden on that.
Okay, thank you very much. Any other comments from the public? If not, we have already, yes, sir.
Norman Wallace from Cundy's Harbor, Redfish and Associates. I would like to point out that at one time, High Head had their own bylaws that prohibited individual docks, and those were specifically changed to allow the homeowners to put in their own docks by the members of the High Head Road Association and subdivision. And now the town is trying to take that option away from them by making these changes. And I'll get into that a little later when we have the public discussion. But I feel that this is kind of a discretionary thing. The town's changing the way they're implementing the rules to prohibit these developments because they've allowed other homeowners in that subdivision since the changes in 2007 to the ordinance to put in individual docks. And now you're changing the direction you're going and not allowing these owners to do so. So I'd like you to consider that as well.
I appreciate that. Thank you.
Hi, good evening, everyone. I'm Tim Forster with Flycatcher. I am an environmental consultant that works closely with the town on many different projects, docks being one of them. I'm speaking tonight mostly as a consultant, not as a resident, so I hope you'll entertain what I have to say.
Certainly.
I do represent several of the other applicants, as well as the ones that are here right now. So the point that I wanted to make was that this change occurred, I believe, in 2007, the original ordinance change, which said that, if you were part of a subdivision, there was common dock and you weren't allowed to wharf out after that. From that point up until 2 years ago, when the planning board denied that last application, it was common practice, I believe, that the code office would look at those projects and say, this subdivision was created prior to that ordinance change, so they chose not to enforce it, is my understanding of how that was looked at. And I know for a fact that I have permitted a couple docks in High Head since 2007, and I'm sure I've permitted several others in other subdivisions. Unfortunately, I don't remember all of them anymore. But High Head, I think, is a great example because they did have the common dock, and during that process, you also go before the Maine Department of Environmental Protection to obtain a permit from them. And with that is a very extensive alternatives analysis that are considered, not only access within the lot, how the dock is built, but there's an entire section on access to public docks, to association docks, to marinas. All of that is discussed through the state process and pretty well vetted by the project managers at DEP. And in this case, a lot of those situations where the DEP still approved those applications, even though it was stated that they did have deeded right access to those, and justifications were provided to those. So I kind of think that's a couple of important pieces that I hope you'll consider. In my opinion, I know this is for a later piece, but I'd love to see the ordinance only date back to 2007. From that point forward, everybody knows what the rule is and everybody knows how it should be. And this is clearly a subdivision that predates all of that. So thank you.
Thank you. And you've pointed out very clearly one of the reasons why we have looked at it to propose an ordinance amendment to what we have right now. The question is not what we would be able to do under the proposed ordinances, and I think, we had a meeting, I think it was last week, with the members of the planning board public meeting to talk about that as well, and to say, if you have a situation where your attorney is saying, no, you can't do it, regardless of what other planning board members or planning boards have done in the past, we should be able to try to find a mechanism in order to be as equitable as possible. And I think that's what those ordinance amendments are looking at. But I guess our question at this point is that based on the legal opinion that we have received so far, how we should act. Yeah. Sure.
Kristen Collins again. I take some issue with anything to the effect that because the lawyer said so, we have to do it. The lawyer is a lawyer, not a judge. I'm a lawyer. I've also given you an opinion based on my many years of experience in this field. The fact that you denied an application based on a legal opinion is not precedent. They didn't appeal that. It didn't go to a court. Until a court rules on this, there is no finding of what the ordinance here actually means. So I think you are able to take the new emphasis that we've put on the distinguishing factors here, like the fact specifically that there isn't a deeded right of access to a dock, and say, maybe we messed up the last time. Maybe there's more information or more clarity this time. And based on that, I wish you had gotten an update. I don't know what that update would have been. But we also didn't want to delay until the attorney could be here and wait for that. But the bottom line is, you are the judge for these applications. You're hearing a couple of different legal opinions, and you have the latitude to choose what you think is correct and fair and most accurate based on the language. And as long, if it goes to court from here, whether you deny or whether you approve and somebody appeals, what you did, whichever opinion you took, that was your latitude to make a legal determination of what your ordinance meant. And it's not going to be ruled arbitrary just because you took one side over the other or you went against your town attorney's prior guidance. So, thank you.
Thank you. As a prior Plan Commission attorney myself, not in Maine, that is true. But the question is, how much deference do we give once we have had a legal opinion from our attorney. Is there any indication that our attorney is going to be updating her opinion at all?
I don't think she has anything to add at this time.
Because there were a couple of distinguishing, of distinguishing things that council has talked about, distinguishing factors from the prior application that we had. Has she weighed in on any of those distinguishing factors?
I do think we can agree that there was some distinguishing factors before that aren't happening now, but I haven't gotten any information as to a new opinion of hers based on this current application. Sorry, I'm not being very helpful.
Yeah. Okay, so I guess, Courtney?
Hello, yeah. It's frustrating being on Zoom because Anyway, I have a question. I am not a lawyer. And my question is, does anyone know the original reason for having a community dock for a group of people as opposed to everyone's having his or her own personal dock? I think we do have to look at the reason that exists. Maybe someone can speak to that. Dan, maybe you can speak to that. But that would help me as a planning board member. You know, if I have any wiggle room of something, I need to really understand the wholeness of the situation.
Okay, I think a member of the public would you come up?
Again, Joe Johnson again. The reason, I guess, is the way High Head is situated. There is a clubhouse there, and we do have a public meaning for High Head residents. It's not for community use. And the reason it is there is because there are about 47 homes that may have moved there with boats that cannot have a deep water dock. So, again, I wasn't here when High Head started, but I'm sure that part of the reason for that was to allow people that wanted to be on the water with a boat to be able to access their boat without having a deep water dock. So that's why I would say that we have the clubhouse. But I will also add that right now there are 13 dinghies there. We've had to enlarge the area for dinghies. At some point, we can't keep putting more people there. So the more people that can have a deep water dock, the better it is. Solves a lot of problems with a lot of too many boats up at the wharf at the same time. So, okay, is that help?
All right.
Yes, that's specific to High Head. I was talking in general. Thank you, Ms. Johnson, for your comments. But I was talking in general as to why the town seems to like the concept of a community dock as opposed to having every individual have a personal dock. I was really, excuse me, looking for the larger picture for this.
Okay.
I don't know the answer, but I would assume that it is something along the lines of less impact on the shoreline, less proliferation of individual docks. The town tends to regulate subdivisions because I think in general, subdivisions are more heavily regulated in Harpswell than individual non-subdivision lots. And so I think that's why this was kind of the step that was taken back in 2007, was to regulate subdivision docks.
All right.
Thank you.
And I do think it's consistent with our comp plan to kind of limit individual private docks. But it's not a quote, I'd have to look it up.
Okay.
All right, I'm going to exercise some discretion that the chair has given here and put the attorney on the spot again for the moment. Because we do have a legal opinion for the last application. There has been no update on this one. So would you please, again, just come up for a moment and explain what the differences are between this one and the prior one, which would make that legal opinion less applicable here?
Sure. In the first instance, that particular property had come in and sought approval under the town's subdivision ordinance and under modern subdivision law. And so I'm saying this, and this idea came to me because Matt Gilley, who was on the select board when I spoke to the select board about this topic, was on the planning board when that application came forward. And what he said was, well, that one, we ruled that way because that was had been through a subdivision amendment. And so maybe the minutes need to be reviewed to be clear about that, but it seemed to me that the board treated that as a distinguishing factor, and I think it is. When you have a lot that's unchanged, that the only reference to any subdivision plan comes from well before the enactment of the subdivision law, that is a distinction. But I think the other point that just wasn't really discussed in Amy Chow's letter from 2024 was the fact that in practical reality, there is nothing in this development that guarantees these people the rights to a dock within the yacht club. A yacht club could be moorings and services and tenders. A yacht club could be a dock, but there's no guarantee that there's a dock. Whereas when you look at other communities' deed restrictions, and particularly more modern ones where these kinds of things start to matter, you see language that says, including rights of access to a community dock. And you just don't see that here. It references this yacht club. And at the time, there was no further discussion about what a yacht club meant. And there still is none. I mean, there happens to be docks, but there is nothing in their bylaws that guarantees there's going to be one. So like I said, if in the next big storm that dock blows away, and the powers that be in the association say, we're not going to rebuild it, there's nothing that those people can point to in their bylaws that says, but wait, we have this right, so you have to rebuild a dock. And I think that is really a distinguishing factor. If someone were coming under today's ordinance and knew they were dealing with that ordinance, they would absolutely have designed this subdivision differently. You wouldn't have a subdivision that's this big with one dock, or a dock this size. And you also just would have much more concrete language requiring that these things be, constructed and maintained in perpetuity. So I think if you go back and look at Amy's letter, there's discussion of the fact that there's the yacht club, but she says, let's just look at the language real quick. She says, one would assume she says, it is our understanding that the yacht club lot was developed as part of this subdivision, and it appears that it has long contained a pier, float, and related facilities. It appears that all lot owners are members of the High Head Yacht Club and thus presumably have the right to use the facility. There are a lot of assumptions that were being made. And what we're telling you today is they have the right to a piece of property that is a community piece of property that happens to have a yacht club, but nothing beyond that is guaranteed in these deeds or in practice in any of the bylaws. All right. Any other questions for me while I'm standing here?
I will note that that's not the only time High Head has been to the planning board for a subdivision amendment. They've been to the planning board maybe 10 times. The road has been to the planning board. There's been road amendments. There's been other lot line amendments. So it's not just limited to that one Hegarty case. There's been a little bit more of a history of the High Head coming to the planning board for amendments over the years.
I get it. In the Higgerty case, though, that involved the specific lot that was under review, and that's what at least Mr. Gilly thought was relevant.
As difficult as these discussions are, the beauty of it is that we really get to get into more depth about what's involved. And, you know, we do have the legal opinion that was issued for the Haggerty application, but we've also got an updated distinction opinion from the counsel for the applicants right now. And there has been nothing from our attorney that has indicated how that would have affected her prior opinion. At this point, I'm going to throw out a motion. We'll see if there's support and see what the planning board thinks. But I am going to move that the remaining section that is outstanding, 15.3.9, that the standard is met based on representations of council, that there is the standard is met based on the finding that the owners of the property do not have automatic access to the High Head Yacht Club facilities.
Specifically the dock, right?
And specifically the dock. And therefore, and since there has been no subdivision amendment related to their property, the prior opinion of town council does not necessarily apply. So in other words, the motion is to say that the remaining standard, 15.3.9, is met.
Mm-hmm.
Is there support for the motion? Then we can discuss it.
I would second it.
Is there any other discussion?
I would just say that they're deed restricted to be in good standing with the High Head Yacht Club. So whether or not the High Head Yacht Club includes a dock or not, I think is a valid question. But they are deed restricted, that they have to stay in good standing with the High Head Yacht Club and maintain that relationship. So they kind of do have deeded access to the High Head Yacht Club.
Just for me personally, I don't
Yeah.
think if it's immediately clear that they have deeded access,
Yeah.
we can't say that they have deeded access.
Right. It's not clear.
Yeah.
Okay. Is there any other discussion? If not,
Did we get a second?
I will ask
Laura?
for a vote.
Jim.
I seconded. Yeah.
Thank you.
Okay, so it's been moved in second. No further discussion? All right. Jim?
Jim Bobarski, aye.
Courtney?
Courtney Snelling's nay.
Heather?
Heather Allen, aye.
Lori?
Lori Falcone, aye.
Dan Hoback, aye. So the motion carries 4-1. That was the remaining issue. So then the conclusions of law, based on that, I move that the planning board finds, in light of these facts, with consideration given to the supporting documentation in the record, that the planning board reaches the following conclusion. Planning board finds that the applicant, David and Laura Abel, have met the standards of the town of Harpswell shoreline zoning ordinance for the installation of a seasonal dock in the resource protection district. The planning board approves the application subject to the following conditions of approval. 1, the approval is not final until such time as the notice of decision has been signed by the chair of the planning board. 2, the approval is based on the application, including the drawings of the proposed dock prepared by Flycatcher LLC and on all submissions and information provided by the applicant at final approval, whether referenced in any findings or conditions of approval. 3, the approval is dependent upon and limited to the proposal and plans contained in the application and supporting documents submitted and affirmed to by the applicant. Any variations from the plan, proposals, and supporting documents, except de minimis changes as determined by the town planner that do not affect approval standards, is subject to the review and approval of the planning board prior to implementation. 4, the applicant shall comply with all state and federal rules and regulations that apply to the application. Is there a second?
Second.
Okay, it's been moved in second. Discussion from the board? All right, Jim?
Jim Bobarski, aye.
Courtney?
Courtney Snelling's aye.
Heather?
Heather Allen, aye.
Lori Falcone, aye.
Dan Hoback, aye. The motion passes
Wait.
5.
I don't think that Courtney can vote yes since she voted no on one of the approval standards.
I was wondering about that.
Yeah. Because you said it's not met, so then you can't say you approve it.
Well, she
Well,
can-
but we passed it.
Yeah, but I
So-
don't think you're allowed to approve it.
If that's it, then I'll say nay. I assumed that since the planning board
Or you
had
can-
made a decision,
Or you
then
have,
of
or
course
the,
I
or
would
you
have
have,
to
or
support
the, or you
that.
have the option to not vote, if that would be your preference. But you,
I always cause problems, don't I? Sure.
yeah.
I'll not vote.
Okay.
All right, so there's
Sorry to interrupt.
so the vote passes
No,
4
thank you.
4 to nothing with 1 abstention.
Cool.
Okay. All right. Well, that was easy. All right, so let's go on to the next one, which is the 187 High Head Road. Let me pull that one up here. And I believe we're in the same circumstance here. This is motion for a seasonal dock in an RP district, map 17, lot 175. Christopher and Richard and Mindy Muddy, or Muddy from 187 High Head Road, proposing to install a dock with a pier and a seasonal ramp. Again, similar to the prior application, all of the other standards were found to be met except for 15.3.9. So the question that I have for the board, is there any comments or questions from the board? Assuming that I'm not going to ask counsel to get up and repeat her arguments again.
No.
Any other comments or questions from the public? If not, I move that the remaining standard, 15.3.9, is met based on the finding that the owners of the property do not have undisputed access to the High Head Yacht Club facilities. Is there support for that motion?
Would second that.
Moved and seconded. Any discussion? Okay, ask for vote. Courtney?
Nay. Courtney Snelling's nay.
Heather?
Heather Allen, aye.
Jim Bobarski, aye.
Lori Falcone, aye.
Dan Hoback, aye. The motion carries 4 to 1. Conclusions of law, I move that the planning board finds, in light of these facts, and with consideration given to the supporting documentation on the record, that the planning board reaches the following conclusions. The planning board finds that the applicants Christopher and Richard and Mindy Muddy have met the standards of the town of Harpswell shoreline zoning ordinance for the installation of a seasonal dock in the Resource Protection District. The planning board approves the application subject to the following conditions of approval. 1, the approval is not final until such time as notice of decision has been signed by the chair of the planning board. 2, the approval is based on the application, including the drawings of the proposed dock prepared by Flycatcher LLC, and on all submissions and information provided by the applicant at final approval, whether referenced in any findings or conditions of approval. 3, the approval is dependent upon and limited to the proposal and the plans contained in the application and supporting documents submitted and affirmed to by the applicant. Any variation from the plan proposals and supporting documents except de minimis changes as determined by the town planner that do not affect approval standards is subject to review and approval by the planning board prior to implementation. 4, the applicant shall comply with all state and federal rules and regulations that apply to the application. There was another paragraph in there about removing.
They have an unpermitted access stairs in float.
Okay. And number 5, all of the existing unpermitted functionally water-dependent structures will be removed from the property prior to receiving a certificate of compliance from the Code Enforcement Office. Okay. Is there a second?
I'll second that.
Okay. Any discussion? Okay. Courtney?
Courtney Snelling's abstain.
Heather?
Heather Allen, aye.
Jim Babarski, aye.
Lori Falcone, aye.
Dan Hoback, aye. Motion passes 4-0 with 1 abstention. Thank you very much. This has been a very interesting and very difficult process. And hopefully, if we can get a good ordinance amendment passed, we can avoid some of these similar issues in the future. So again, thank you all for all of your patience and your hard work, and much success to you.
Yep.
All right. Should we take a 5-minute break before we,
We go get some water.
okay. We're going to take a 5-minute break, and then we'll,
A minute or two.
yeah, just a couple of minutes, and then get back and talk about the new
I
ordinance.
just think that everybody's here is going to stay for the public hearing.
Oh, okay. I didn't know if you,
Yeah, so, cool. Tiny cup. Norman is here specifically for the public hearing.
oh, okay.
Get up and stretched out.
Okay, so we
Hey, how's
have,
work going?
Good.
You still buried?
No, thankfully. Less busy. But when I'm less busy, they try to find ways to make me busy, so.
okay, so where do we have our ordinance amendments here?
Should we at the top of the page? Are you looking on the planning board page? Oh, yeah. Oh, it's right there.
Oh, okay.
Norman tried to accuse me of not having it on the website. I was like, I think I have it on the website. So, anyways.
Okay, and then we will,
I opened it, right? You got it, right?
yeah.
Okay. I have paper copies too.
I think we just saved about 20 grand in attorney's fees.
Yeah.
Harpswellmaine.gov. I keep wanting to do .org. Okay, now I cannot find it back.
I'm glad it went that way.
Hmm?
I'm very glad it went that way.
That was
Based
fun.
on everything, I think it
Yeah,
was.
the fact that we've given docs there before too.
Right.
I was
Right.
saying to Jim, we just saved about 20 grand in attorney's fees too.
Mm-hmm. Oh, yeah.
Yeah.
Yep.
All right, if everyone's ready, we can reconvene here. All right, I'm calling the meeting of the Planning Board back to order. The next item on our agenda is a public hearing on a proposed amendment to ordinances related to the regulation of individual private docks and community docks. They are concerning shoreline zoning ordinance sections 15.3.9 and 15.23, subdivision ordinance 7.17, and the definitions addendum for community docks. All righty.
I will say, as we open this public hearing, the planning board did hold a kind of a workshop style meeting last week, just to kind of introduce the board to the amendments. They did have a number of questions and clarifications that they thought were going to be important. So we can rehash those tonight, or we don't have to, but I did include that in the material over by the door. And it's also, those comments are available on our website.
All right.
Some of them are substantial and some of them are small, but I think there were a number of comments.
Okay, since the planning board has had an opportunity to meet, are there any initial comments that the planning board would like to make before opening it up to the general public? All right, well, this is a public hearing, so we would really like to hear from members of the public concerning either the initial draft or questions which members of the planning board had raised at our meeting last week.
Yes, I have a question.
Yeah, please.
Hi, my name is Mindy Muddy from 187 High Head. So my question is regarding, in the absence of private docks, is the town's preference to have moorings kind of scattered about our waterways? Is that what you prefer?
You would have to look at the harbor management plan and the harbor and waterfront ordinance to know how we manage moorings, and maybe Redfish is better equipped to answer that question, because I'm not the harbor master, so I don't know. But I do know that there are certain areas that are better for moorings and certain areas that are worse. And then you get to a point where areas get very congested, and you kind of have to spread them out.
So there is no solution, you're saying?
I think
to
it's in
this
state
issue?
law that you have to be given a mooring Kristen maybe can correct me, but if you are a waterfront property owner with at least 100 feet of water frontage, you have to get a mooring within so much distance of your house. So you get preference to having one close to your property.
Kind of like in front of the property.
Yeah.
Right. So you're saying that for High Head specifically, Harpswell would prefer that we had moorings all about the water instead of granting private docks.
I don't know that there is a preference. I know that you have the legal right to a mooring near your house. But I don't know that there is a preference either way. I couldn't speak to that.
Okay. I just thought it was curious that you would that seemed like the obvious solution, but if that's, the town's I don't know, position is to deny private docks. But that's prior to tonight.
Yeah.
Yeah, I think one of the differences between a dock and a mooring is, and I'm just kind of speaking for myself right here, is that when we're taking a look at applications for docks, we're looking at the possible impact on the fisheries, how far, may it affect navigation? And probably more important than that, what we were looking at is what is the effect on the shoreline? Are we affecting an area where we have eelgrass? So there are all those additional considerations that we have in putting out a dock as opposed to a mooring, which is, probably environmentally less of an issue. So I think that would probably be my best answer.
Okay, thank you.
And of course, we don't want to have a proliferation of the idea of a subdivision having one community dock is so that we don't have any more docks really than are necessary to preserve people's rights.
Okay. Oh, thank you. Appreciate that.
Yeah. Are there any other comments from the public?
There. Norman's got to have a comment.
Yeah, I got a few. Norman Wallace from Redfish and Associates again. I do want to point out a concern that I have to the address to the change in the shoreline zoning ordinance for community piers and docks 15.23.1. And the change that's being proposed gives the town a cutout for their own rules. So it's basically saying, I feel like it's saying that you want everybody else to abide by the rules, but the town doesn't have to. And I'm wondering if that's really an appropriate thing to be doing.
I agree that it comes off that way. But I think that the issue is not so much of 15.23.1. It's that the definition of community docks lumps subdivision docks in with municipal docks. And that is, I think, the issue. And this was our way to fix that issue without creating new definitions and new standards within the shoreline zoning ordinance. Because my point of really pushing for this change is that if we ever wanted as a town to build a commercial fishing pier, we can't. If you can't go over mean low water. Is that what it is? Yeah, mean low water.
It also applies the width limitation.
Right.
But then
I mean, it's
I
really.
would say that gets into the commercial a commercial dock
Right.
has a different set of standards. So then you have to determine whether it's a community recreational dock or community commercial dock and
Well,
which standard would apply.
A community dock, the definition is on the previous page. The last sentence is, or on town-owned land having the common right of use by the general public. That could be residential, it could be commercial fishing. But I didn't want this to prohibit, the future ability of the town to build a more commercially accessible dock.
And I understand that.
And I know it reads kind of poorly
my
that we're giving
concern-
yourself a carve-out, but
My concern is the way it's written. Because it doesn't address that. It just says, you know, we don't have to apply the rule to the town. So, maybe it needs to be reworded in the definition, or, you know, because we're already looking at making addendums to the definition, right? Changes to the definition. Maybe that needs to be addressed somehow. Okay, I'm not opposed to the town building commercial docks. I build commercial docks for people all the time. So I just feel like it needs to be a little bit better worded. And I can't really give a good definition of how I'd like to see that or what might be best.
We had talked at the previous meeting about maybe doing, for 15.23.1, having a section for community piers, docks, and wharves that are subdivision docks, and a separate set of standards for community piers, docks, and wharves that are municipal docks. And so we just have two sets of standards, instead of having a set and then giving the town
Well, I mean,
carve
could you do like a 15.23.1 point A, where
Yeah.
it's, you know, recreational use versus commercial use standard? That way, because we know a lot of the big commercial docks in town are cooperatives amongst the fishermen. That potentially gives them access to that same cutout if somebody wants to come in and, say, build a cooperative fisheries dock or replace one, because a lot of the commercial fisheries docks need to go below the mean low tide to allow easy boat access.
Right.
And a lot of the existing ones do. But it also gives a way for, in the event of existing docks that fail, which there are a large number of them in town that are in very poor repair, that if the people started looking for companies to replace them now, they'd be looking at the same situation they were post-2024 storms, where they're talking years out to get the work done, you know, because they're such massive structures. If they lose a dock and they've got to wait 2 or 3 years for funding and permitting, now they're outside the window of being able to do it as a permit by rule and put it back in kind, and they're looking at having to go for a full NRP permit. By these standards, they need a cutout to be able to put back what they had.
No, these standards only apply to community piers, docks, and wharves,
What
which by definition are subdivision docks, basically subdivision docks or municipal docks.
Okay,
And for some reason, when we made this standard, we put them together.
okay.
This doesn't touch the commercial
Okay.
dock standards at all.
Okay.
It's interesting you bring that up. That's one of the things that we talked about at our meeting last week, is that I took a look at that and I said, if the people of the town just don't scream when they see that the town is excluded
Well,
from regulations.
that's something I'm gonna bring up too, is the cutout here opens for the town to have a blanket cutout, potentially opens the town to people taking it in their head to fight the town on it, because why does the town get its cutout if I can't do it? You know, why can the town do it if we can't? You know?
Because
But-
the town's docks could be commercial and they could be residential, so to limit them to 6 feet wide is,
Then I would say that
Premature.
maybe there needs to be a stipulation in here that municipal docks for commercial purposes can exceed the standards set forth, rather than just saying any municipal dock. Rather than just saying the town gets a blanket cutout, narrow the cutout down to, if the town decides to put in a town landing dock, like Potts Point being a prime example, or they want to get a commercial dock and put one in, then they get a cutout for that for those specific purposes.
Yeah.
Because I could see an argument for a dock like Potts Point, the town dock, being built 8 feet wide to allow better pedestrian access. Okay, because 6 feet wide is okay for a couple of families that are probably, or one family that's gonna be headed one way and as a group and coming the other way as a group. But if you've got a family going each way, that's 3 feet wide, that's adequate space to pass unless people are lugging coolers and stuff. Now you've got congestion. So I would probably encourage the town to narrow their cutout to reflect municipal versus private.
Okay. Makes sense.
Yeah.
And I'll kind of use that to segue into one of my other concerns about these proposed changes, and that is something that was brought up earlier about how the town has been applying the change in the 2007 shoreline zoning ordinance, where they've allowed subdivisions that existed prior to 2007 to continue to allow the residents to put in individual docks, and only applying that ordinance to subdivisions created post-2007. I feel like if the town is gonna enact the change and apply it to all subdivisions, then it's opening the town up to more legal conflict with its residents and more potential for the town to have additional costs in legal fees when people decide that they really want that dock on High Head or Dowdy Point or wherever, and the town's allowed their neighbors to put them in, so why can't I? So I'm gonna go get my lawyer and invest some money in taking it to court. So there is a truly legal definition put in place. And then what happens if the court decides against the town has to come back and review the ordinance and potentially change the ordinance to reflect that concrete legal decision. So I kind of get where the date for the 1971 September 23 application comes from, because I believe that's the date that the NRPA was established. Is that correct?
It has to do with subdivision law.
Okay, all right.
Because everything post 70, this date, all those subdivisions were signed by the planning board,
Okay.
but pre that date,
Okay, 'cause-
most of them were signed by the municipal
All right,
officers.
because I
So the select board.
believe the NRPA, and you should probably answer that better, when was the NRPA established?
I have no idea.
Okay. 78, okay. I knew it was in the 70s. So I would question taking this ordinance all the way back to 1971, again, because of the way it's been treated since the changes were made in 2007. I could see an argument for dating it back to the 2007 ordinance changes and applying it from there forward. But to go back to 1971, probably half the houses in town didn't exist. High Head alone has quadrupled the number of residences, at least, that they have since that subdivision was established. Even if half the people there wanted to use the yacht club, they don't have the space, and there's nowhere for it to expand. They've already expanded their mooring field out into the sound. There's no more room there without interfering with more fisheries access to Harpswell Sound. They physically don't have the space to put more dock in. So the only other option for a subdivision like that is to procure land somewhere else in the subdivision if they can manage to put in another dock. And that's a whole different ball of animals. So that's one of my concerns is, and it's not just High Head, how many other subdivisions were established prior to 2007 that have dramatically grown in number of lots and houses since they were established, you know, that had community docks built when they were originally established, and the dock was built to handle the dozen houses they had, and now they've got 24, you know, or more, or whatever.
Well, just to understand what you're saying, you're suggesting that rather than going back to, that the language we're using going back to 1971 should instead be to 2006.
Yes. I think that's a more realistic ask and would be less of a conflict within the town's voter base to get approved than going all the way back to 1971. Because if you look at the census, the median age in Harpswell is in the mid-60s, which means going back to 1971, you're going back to almost as long as the average person in Harpswell's been alive, or dang close to make a ruling and saying everything after that, you know, is now changed. So I would encourage consideration of making it dependent on that 2007 date rather than the 1971. I think you'll find that that's going to be much more palatable to most people and is more in line with what the town has been doing for the last 11 years. Or I'm sorry, the last 19 years, you know. And my other concern is, let me gather my thoughts here and see what else I have. Couple of my questions go back to some of the ordinance as they currently exist. And I don't see that they're being resolved with the proposed changes. And that's a conflict between the shoreland zoning ordinance and the community dock. And I know there's a community dock portion of the subdivision ordinance. And I know there's a hierarchy of the ordinances and which ones take precedence. So maybe Margaret can define this for us. Shoreland zoning ordinance 15.3.9 specifically calls out subdivisions with deeded rights to access to a community dock can't have a new dock unless it can serve a third of the lots in the subdivision. But then in the subdivision ordinance 9.17 under community docks, it says that any subdivision located in whole or in part in the shoreline zone, no new wharf, pier, or dock and or float shall be constructed to service only one lot if the upland area of the wharf, pier, dock, or float is proposed to be located may reasonably be arranged to service more than one lot. So you've got one subdivision, or one ordinance that says that if they can argue that it can't reasonably be made to serve more than one lot, then it's okay. But the other one says, no, it has to. So which one takes precedence, and should the terminology be changed so that those two ordinances are more in line with each other? Because I could make arguments all day long for reasonability and who gets to define the reasonableness of an individual dock for an individual property. But then you go back and butt your head against the shoreline zoning ordinance. So which one's in charge? And I think those are my major concerns at this point.
Those are really helpful.
I've also, I had a note here that some of these changes may encourage some of the local developers to be more inclined to do lot splits to individual lots, so they can put individual docks in on those individual lots, as opposed to taking a large property and making it into a subdivision, because they're developing it for a profit. It's gonna make them more money if each individual house has its own dock as opposed to a subdivision. I know the town wants to see fewer docks, fewer impact on the resource, but there's legal methods for them to do the simple splits as opposed to the subdivisions. And if they're gonna be limited by subdivision rules going forward, they may be more inclined to go the route of simple splits. And I have a specific developer in mind. I'm not gonna name names, but I know that that's one of his current projects, is going through simple splits rather than a subdivision, because of some of those concerns. So, anyways, those are my thoughts.
Thank you very much.
Thank you.
Hi, everyone. I'm Tim Forrester with Flycatcher. I guess I would start out by, in general, I actually think this is a great idea. I think common docks for subdivisions is a smart move. However, that's a complicated thing to do. It's very hard to draft an ordinance, and it's very hard to predict the future. And if you're going to do something like this, there really needs to be a lot of thought put into where does this go, how is it constructed, how is it going to service all these lots, how are people going to access it. There's a lot of potential moving parts in it that I just think make it potentially complicated in the long run. One of the concerns with the way the ordinance is drafted itself is just in the first paragraph. I, like others, support the fact of from the rule changed in 2007. I feel it's appropriate to go from 2007 forward because everyone knew the rules at that time. From that point forward, builders could take it into account. They could plan for it. They could design for it. There are provisions in the first part that talk about the older subdivisions, and if they don't have a common dock, they don't fall into the same criteria. But that doesn't really work in practice in all locations. Like Ms. Johnson, who spoke earlier, if High Head wanted to build a second dock somewhere, how are they going to do it? All the lots are sold, all the lots are developed. Where are you going to put it? How's that going to work? It would be a monumental battle to pull off something like that. So one of the other points that I wanted to make was, you talk about if you have a large subdivision and someone is within half a mile of that subdivision, if they're beyond half a mile, then they wouldn't have to meet this standard, and then they could have their own dock. I'm curious where the half mile comes from, and there are a lot of properties in town that people may have a tremendous amount of frontage. So if you're just going to the property line, but their house is way on the other side, that could be 1,000 feet, a few more than that. Yeah, and then just to reiterate what I said earlier, it was the practice of the town that they would let you, you could get a dock in a subdivision if it was done if the subdivision existed prior to the ordinance change. So I feel that is consistent and potentially consistent with how other rules happen within the town. Do you often make rule changes? This is more of a question. Do you often make rule changes that date back to 1971 like this? That feels like quite a stretch to me. And then the last question is, has anyone really sat down and looked at all the subdivisions, looked at how many of those subdivisions have common docks, how many of those subdivisions have individual docks? Is there any data based on this, or is it just driven by the fact that we want to make this change? So, thank you.
this is more as a private resident of the town than a builder, but I guess as a builder as well. I would be interested in having the town provide a list of the subdivisions, when they were established, and what permits have been granted in those subdivisions as far as dock building goes since 2007, to see just how much of that allowance for existing subdivisions to expand has been made. I know it's a lot of work and would take some time, but I think it would probably behoove the town to provide that in part of the information if it's gonna make these changes to the ordinance, to let the townsfolk see, well, we've been doing this all along, but we wanna change the rule, you know? As a resident, I have no idea how many subdivisions are even in town. I know there's a difference between subdivisions and road associations, you know, but I couldn't tell you which ones are which, you know, and which ones even have community docks. So, and I'm on the water all the time.
It's hard to tell who has community docks because of the way that the assessor assesses them. And so it limits, I mean, without going through each subdivision and looking at it and understanding it and knowing it, it's really hard to tell.
Yeah.
And looking at it, if they've deeded access, I mean, that whether or not they have a community dock is one thing, but do they have deeded access, then it's a lot of work. But I can provide you with a list of subdivisions, and I can provide you with a list of dock permits, and you can cross them if you really want to.
Well,
It's hard. The pre-71 divisions of land that would be impacted by this rule, I believe, and I'm not sure, but I think it's High Head, Indian Rest, and Harpswell by the Sea. There might be more pre-71 subdivisions with community docks.
I don't know when Dowdy Cove was established.
After
Typical.
71.
Was it? Okay. See, that's the thing. Maybe what we need is a list of the subdivisions
That I can provide you. We have
and their
a list of
establishment
subdivisions.
date, so we can see which ones would actually be affected.
Yeah. I mean, we have
You
all
know,
that.
because if they, you know, if you're gonna apply this rule back to 1971, then the ones prior to 1971, like High Head, theoretically, it doesn't hurt them, but the ones that were established between 1971 and 2007, which are probably a much larger number of subdivisions, would be affected by it.
I mean, everybody would be affected if you're in a subdivision with existed legal deeded access to a community dock. I mean, that's really what we're saying is, this ordinance is saying to limit private docks if you have legal deeded access to a community dock and you're in a subdivision. I mean, that's really what it's trying to say. And then the pre-71 ones are trying to say, like, is it if you're, because they didn't really plan for community docks or this deed restriction, if you're not within a half mile, then maybe it's not reasonable for you to use the community dock.
Well, and to go back to what Tim was asking about where that half mile came from, how are we measuring that half mile? Is it, we're taking a circumference on a map? Or are we calculating based on travel distance by road?
Somewhere.
It's a radius.
So, I find that kind of questionable because some of the subdivisions like High Head are pretty spread out. Or like Harpswell by the Sea, where their community dock is at one extreme end of the subdivision. And the people at the other end that are more than half a mile away don't have waterfront access.
So they
So they're
already use,
stuck using the community dock.
they already do use the community dock.
Yeah, so they have no options, but everybody that does have an option for something other than a community dock is now no longer able to do that because they're within that half mile circumference. So, you know, it raises questions. Anyways.
Kristen Collins again, and why am I here? My clients already got what they wanted. Because I'm a land use geek and I'm invested now. But I found a couple of things poking around that I thought might be of interest. To this point of should it be 2007, there is another provision in the shoreline zoning ordinance that was amended. It's a height provision limitation, and it says for structures existing as of March 10th, 2007, they're grandfathered. And that was the date that that particular ordinance amendment had gone in. So that, that's usually what happens. But I found it particularly interesting on that point in the 2007 annual report. There's an update on, planning matters. And it says at the town meeting in March 2007, voters passed 2 ordinance changes proposed by the CPIC. And then it says a requirement for building a single common dock rather than a number of individual docks in new subdivisions on the shore. So in my presentations on these 2 applications, I can't get up and say, no, the ordinance didn't mean that. Nobody meant that this would be the way it's applied. It is written in this way that it doesn't distinguish new subdivisions from old subdivisions. But I think that was the intent. And that's certainly what the intent normally is, because zoning just always builds in nonconformity. The new rules apply as of the date this is enacted and going forward. So rather than have this whole tortured structure where we're making exceptions for some people for a half mile out, wouldn't it be a lot easier to just do it the same way we do every other land use ordinance and just have a grandfathering date on the date of enactment, like you've done for other things, even at that same town meeting, and as seems to have been the intent? The other thing is I mentioned before, some of this grueling work of trying to figure out which subdivisions were pre-1971, had community docks, and also had a lot of other docks that had been built since. So what my list, and this was not exhaustive by any means because it's very time sensitive work, but Indian Rest, that one was formed in 1900. I found 5 assessed docks there. Johnson Point was formed in 1973. That one I found 2 assessed docks in. Then High Head, I can't even count real quickly, but it's about a dozen. And then I had Longreach Mountain, which is Lombo's Hole. That was formed in 1975, and I found 5 already constructed docks there. So it would be pretty arbitrary to just say, at this point now, we're going to retroactively change the rules for the people who just never got around to building a dock in those subdivisions. So no vested interest in this. My clients, thankfully, have demonstrated that in their case they have a distinguishing factor, but I think it's fair to kind of just make things a lot simpler and just look at least at 2007. Thanks.
All right. Other comments from the board based on what you've heard from the public?
Yeah, what is the reason that we're going back to 71 versus 2007? I wasn't here for the meeting, so.
That
Sweet.
question was never raised when we talked about it, I don't believe.
It's not going back to 71, it's going back all the way. 71, there's just a distinction in subdivision law. So it's like when modern subdivision law started. And so the way it was written before, that you had to have, it's trying to kind of clarify the word subdivision. So we're trying to capture modern subdivisions and divisions of land pre-71. So it's just trying to capture everything. But they're called different things and they're approved by different people. So it's putting them all in the same bucket. They're just divisions of land.
I have another question for you. Now, the reason why we're having the public hearing tonight is because it would have to go to the select board by next week.
The select board needs to finalize the warrant for the November ballot next week.
Okay, so
So
the time crunch for us to do this right now, and with all of the questions that have been raised, is do we get it on the November ballot, or do we take a look at this and take into account all of the other questions that have been raised and put it on the March one?
correct.
Because I'm thinking, who's going to, I don't see us having a whole lot of wharf applications in November and December. But if we could clarify that,
Look at Tim Forrester, he's like,
well, yeah, you never know, do you?
I think there'll be a proliferation of high-head dock applications at this
Could
point.
be.
Yeah.
I got 3 permits, just waiting for DEP approval to get submitted to you guys, so.
Okay.
All
But
in
based,
all, though, I agree with what you're saying.
but based on what our decisions were, if you're talking about a proliferation of things from High Head, for example,
Yeah,
I think our decisions tonight have probably clarified some of those.
yes, but this would further clarify it.
Yeah.
So I think that it is, personally, I think that we should stop and take a minute to revise this. We can have another public hearing or another meeting and discuss this. And I think we should also keep the select board informed because they need to know, if they want us to revise this and make sure it gets on the November ballot, or if they wanted us to take a little more time and put it on the March town.
Put it on the March one?
Feels rushed.
Yeah. There are, just, my opinion, looking at it, there are enough questions that have been raised about consistency with the dates of other amendments, questions about clarifying the difference between a municipal dock and a private dock to get the language clarified there. I'm still not sure where, and one of my major concerns early on was this half a mile question. And if I'm 5 feet inside of that half mile, I can't do it, but if I'm 5 feet out, and that was one of the areas, we were talking about a lot earlier about areas where the planning board has discretion and areas where we don't. And this should give us an opportunity, if we're gonna do this, to give us some discretion to, the greatest practical extent or something like that as well.
I disagree with that, but that's for another.
Well, I know, that's,
Anyways, it is on I did include it on our list, even though I didn't.
I know,
consider that.
yeah.
Okay,
Yeah, but we don't agree on everything, but that's fine. That's why we have a number of people doing this. But is it the consensus that we should just advise the select board that we should work on this to get it onto the March warrant rather than on November?
I don't know what they will want us to do. So if we could continue this, we could, based on what they want us to do, we could either revise this and hold another public hearing in the next month, or we could,
But wait a minute, they have to approve it next week, don't they?
they have to approve the language that, they have to print ballots. So they need to approve the language that's going to get printed on the ballot. And all that's going to say is, does the town vote to approve, do you vote to approve this amendment to the ordinance, sort of thing. The actual language of the amendment doesn't need to be done next week. It's two kind of.
But are we going to be, are we comfortable enough at this point that we're going to have language that's going to be workable in time to get it on the,
Right.
to explain it on the November ballot? Yeah, Courtney.
I'm feeling it's very rushed,
Yeah, me too.
frankly. I think people stood up and brought up issues that we have to address. We might not agree with everything they brought up, but I think they were all important points. And I would like to see us wait on this, if at all possible, give us more an opportunity to do a good job.
Yeah.
And listen to the citizens who have spoken.
Yeah.
Because it's going to be around a while, so you want to get it right the first time and not have issues down the road because it wasn't done right.
Correct, but it was the select board who kind of started this process, and so I feel like they need to be able to weigh in and say, mean, it's really important that we do it in November, or let's take a little more time and do it in March.
I would just like to add that I currently don't have any projects that would fall within subdivisions. The two that I had, we've already been addressed. If I were to start a new project today, it would be March before I got my DEP permits, before I could then come to the board and, or at least to the selectmen and finish that process. So I don't see any reason why it needs to be rushed. Thank you.
Thank you.
Thank you.
As somebody with a double vested interest in this, as both a dock builder and a voter in town, I would encourage the board and the selectmen to make sure that everything is in order before they put this on a warrant. Don't try to rush it for this fall. Don't try to get a ballot printed for this fall with an ordinance change on it when there's no concrete phraseology or terminology for the ordinance, because then what happens if nobody can agree on it? We have the ballots that don't work, you know. I would strongly encourage a slow, methodical approach to making this change, because it could potentially affect a lot of the character of the town, so to speak. We have a boat on our town seal, and people come here for our access to the water. So
I think I would try to avoid the word slow, but systematic.
you're right.
You know, but
Not the best word,
but systematic, because you know the points that you brought up tonight, and with your experience working in the field, that's a very important element too. And same with flycatcher. So you know, if we were to have an additional few months to work through some of that, we would really encourage you to take a look at it and talk about the things that not only affect you as a professional, but that affects your clients as well. And because, you know, when we get up and present that, we're going to have to defend the ordinance amendment, and I don't want somebody articulate like you coming up and saying, you really didn't think this out very well, did you, fella? So, yeah. What's the feeling of the board at this point?
I'd like to see if we could go to the selectmen and see if we could postpone it until March.
I would agree. I think any proposed amendment at this point would have a better chance in March after a bit more diligence and consideration.
I agree as well.
Courtney?
Oh, I already spoke to it, and I think, well, I'm sure the select board will watch our recording in great excitement, but no reason why why maybe Margaret can't say, you know, we discussed it seriously, and this is the feeling of the planning board. I mean, they may not, the select board may have their own reasons for wanting to do it now, but at least we could share our feelings on wanting to do as good of a job long-term as possible.
Yeah. Okay. Then at this point, we don't have to move the ordinance amendment, but we can just ask Margaret to relay the information to the board or to the selectmen, right?
Yes, and something will get said about it at the select board meeting next Thursday. And we'll discuss it at their meeting.
Yeah.
That would be the 27th.
Yeah, and if, you know, if it makes sense, I would be more than happy to attend as the chair of the planning board as well, and members of the board as well, to talk about the reason why we're taking the position we are.
Awesome.
Okay.
Great.
And that is it for the public. We'll close the public hearing. There any new business? No? Planner update?
You know it. I want everybody to know that Christine Donovan Hall withdrew from the planning board. The select board will review and accept her, with her resignation at their meeting next Thursday night on the
Okay.
27th at 6 PM. So that's the first thing. The second thing is that we did have it wasn't a workshop. Never mind. That's out. We did schedule a workshop for September 23rd at 4:30 PM. A joint meeting with the Housing Committee. The Housing Committee is working with a consultant right now to draft some ordinance language related to housing to bring us into compliance with the state legislation that has been passed over the last couple of years. We're going to get the first draft of that ordinance language in the middle of September, and so they really wanted to be able to bring it to you and get your feedback on it as soon as possible. So we'll have that meeting with you and then bring any feedback back to the consultant, and then there'll be another draft of, another round of amendments drafted based on our feedback. I think that might be it.
Okay. Anything else from the board?
No.
If not, the meeting is adjourned. Thank you.
Great.